Showing on this episode of the program, another senior advocate shares with Law Weekly his views on some of the discussions from the recently concluded National Summit on Justice 2024, jointly organized by the Federal Ministry of Justice, the National Judicial Council (NJC), and the Nigerian Bar Association (NBA). Also showing on the program, highlights from the Women in the Profession WIP Nigerian chapter event for female lawyers on strategic rainmaking, empowering women for the future. Plus our recap of the top trending stories in the courtrooms. Hello and welcome to the program. I'm Shola Shoyele. My guest, Senior Advocate of Nigeria, Olukayode Enitan, believes that the legal profession needs to prioritize good character and appoint into offices persons with proven integrity. Against the background of the recently concluded National Summit on Justice, which held in Abuja about 2 weeks ago, I began with his views on the key takeaways from that summit and what the legal profession should focus on in terms of reforms.
I believe everyone agreed that there is a challenge, and the challenge is deserving of solutions. So, I think the first, like somebody said, the first key to solving any problem is to first agree that there is a problem. And at that summit, everyone was of the firm view and agreement that there is a problem. Now, solutions. Each of the speakers and participants, both in the papers presented and the comments that were shared, provide solutions. But for me, what was key and which agreed also with what my views had been, is what Professor Yusuf Ali, SAN, said. He emphasized the issue of character. And the problem is not really with the system or the mode of appointment. It is the character of the appointer and the character of the appointee. Once we are clear that, yes, we have appointed men and women of integrity, it does not matter who appoints them. And for that to happen, it has to be merit-based, and for everyone to appreciate the fact that we are doing this on the basis of who is the most competent. So we need to focus on who are these individuals that we are appointing. Let them be those who have the intellect and the character to do the job of adjudication. So for me, that was very, very instructive. Again, it was also agreed that there is a need to do some tweaking with the concentration of power in specific individuals holding specific positions. So that is necessary. Otherwise, which is what is existing now, you have one person who's taking a decision here, and he goes to the next body, the same person is still there. So you need to have some measure of independence of opinion, such that no one feels, oh, I must go this way because I'm not sure what's going to happen next.
Because you've touched on the issue of merit in the appointment of justices, I want us to dwell on that a little bit deeper. The situation where we've seen in recent times where judges put forward their children, their siblings, family members, even mistresses, as we've heard, for appointment into judicial offices. Did the summit touch on that? Because even the CJN has been called out in recent times on these issues of nepotism. So did the summit address issues like that?
I would not say because that was not a specific item of discussion. However, before the summit, that had been in the public domain. For me, anybody can aspire to be a judge or a judicial officer. The question is that individual worthy of that office by his own creds? If exams are done and the person passed and passed extremely well, the fact that he's the son, daughter, or friend of anyone should be of no moment. It becomes an issue where that individual is a mediocre. If he's a mediocre and then you impose him or her over and above other people, then there is a problem. I have no problems with everyone being somebody's children. What I have an issue with is this person is undeserving, does not have the intellectual capacity, lacks the moral capacity, and is totally unable and unfit for an office, and then you put the person there. Then there is a problem.
We've heard that some bills will be put forward by the AGF as a result of the outcomes from this summit. While we await those bills and maybe the public hearings that will follow, what in your own views are the practical things that you think that we can do to make our justice system work better, to put reforms in place?
Timelines. We need to set timelines, and we need to enforce those timelines. Now, by timelines, what do I mean? Why are we in court for 6-7 years at the trial court? It's totally unnecessary. So set timelines. If we set these timelines, and everyone, and for me, I'd also want a compensatory cost regime. If you file a frivolous action, you should be made to pay. That is what operates everywhere else but in Nigeria. You see someone, he goes to court, he knows he has absolutely no reason to go to court, but he files his action, holds the hand of the other person, and for the next 4-5 years, they are going up and down, and then someone goes on appeal, 10 years, they are back in the high court. I want timelines. I want a compensatory cost regime such that if you make the mistake, you even defend a case that you should settle, you are made to bear the cost. Once counsel and litigants appreciate the fact that I should settle and you do not settle, then you are going to pay. You shouldn't go to court. You go to court. You are going to pay. Then we will all begin to sit up.
Away from that interview, we move on now to the Women in the Profession Nigeria Chapter Roundtable Breakfast Session for female legal practitioners on strategic rainmaking, empowering women for the future. Here are some of the highlights from that event. The Roundtable Breakfast Session of the Women in the Profession Nigerian Chapter, held on the premises of the Tier 1 law firm Udo Udoma and Bello Osage. Gathered here in this meeting room are female legal professionals from different organizations, from litigators to commercial lawyers, arbitrators, in-house counsel, public office holders, and many others. The women are excited about the opportunity to learn and share ideas on the theme, Strategic Rainmaking, Empowering Women for the Future. They are also excited about the lineup of speakers. South Africa's Tamsin Fremantle has extensive experience facilitating African capital markets development, and she led discussions on how to approach business development, brand positioning, and client management.
Don't think that just because you are the only woman in a meeting of senior financial people that you shouldn't be there. And that goes to that point that I said was made by a female Nigerian lawyer, which I loved, which was make space for yourself at all tables. Don't think that you don't deserve a space. And I would say that 25 years ago, not even 15 years ago, I think 15 years ago I was probably okay. But 25 years ago, when I was starting out, that's what I would have said. You have earned your place at the table, you deserve it, and now contribute the way that you can because of who you are.
This was followed by a fireside chat with Dr. Mama Bello Osage, partner emerita of Council, at Udo Udoma and Bello Osage, which she co-founded about 40 years ago. In 2019, she retired from her role as senior partner at the firm, but continues to offer her expertise and experience. Her pivotal role during her career continues to inspire many old and young lawyers, and this group of female lawyers gathered here are desirous of getting practical insights on how to navigate the legal landscape, build a successful legal practice that will transcend generations and leave an enduring legacy for future leaders to follow. Dr. Bello Osage did not disappoint. She talks about what the journey was like in 1983 when she co-founded the law firm with her partner, Senator Udo Udoma.
I think we were very clear that we wanted to start a firm that was not what had been the traditional litigation firm of Nigeria many years ago. He and I decided that we wanted to have a firm that was primarily a corporate-facing law firm, so one that dealt with businesses. And we wanted a firm that was structured in such a way that it would live beyond us. So we were looking at, I guess, primarily American models, to some extent the British models that had started becoming better known, I would say. We have therefore to think about what is it that would keep a firm going beyond us, and thinking of things like who would we want to work with? How would we ensure a succession that made sense? How would we ensure financial viability? These were some of the concerns that we had at the time. And that required building what I guess now would be a brand, but I guess we then thought more of as a reputation, a place which would make a difference. And I felt particularly strongly that it was important to make sure that it would be a firm where women could work comfortably. And it's an issue that I think a lot of firms didn't necessarily think about because they happened to be started mainly by men.
She also talks about the need for a business development plan, even with starting up as a law firm.
What does a startup go through? You are trying to find clients. You are trying to establish what your market is. There's so many things that are relevant in a startup that relate to the establishment of a law firm as a business. What you do as a lawyer is only part of the business. It's like selling milk. I mean, you are providing a product that effectively comes from your brain, but that's what you are selling. So think of it in that respect. And that's when I began to realize that actually we needed to be more deliberate about the business side of the law firm and not just focus on the
reputation,
law,
like what you started
with. Just saying, oh, I'm a great lawyer, and then you sort of sit around and it's like things will fall in my lap because this is the case. Sometimes they will, but that's not what is going to sustain the firm. Think long term. You have families, you have children, you are creating value. What are you going to do about transitioning that value to your children, whether it's by way of money or whether it's by way of business? Don't just assume, oh, it's fine, it's keeping me busy, it's paying the bills, and when I retire, then what? When I die, then what? That's not what I think we seek to achieve. So I certainly wanted a firm that lived beyond me, and I think I'm grateful that the firm has actually been able to pay me.
She also speaks about how she was able to juggle wifely and motherly roles with being a co-founder of a growing law firm.
I think that anybody in that sort of position, you have to create an ecosystem of support. and it has many pillars and many legs. And I talk about family, including husbands. I relied on, to some extent, my mother-in-law. Obviously, I didn't have family locally. And I give a lot of credit to my nannies at the time. They were extremely helpful to me. And what I liked about them was the fact that they acknowledged that they had a role in developing the children they were looking after. So it's one of the things that I always say to people, please treat your staff well, because they can support you in so many potentially unacknowledged ways, but they can make an immense amount of difference.
With initiatives such as this, the leadership of women in the profession WIP Nigerian chapter reiterated its vision to continue to serve as a learning and leadership resource center for the development of the Nigerian female lawyer, while providing an inclusive and safe space to network, seek support, develop capacity, and leadership skills. Thanks for staying tuned. The Inspector General of Police, Kayode Egbetokun, has stressed the need for lawyers working for the Nigerian police force to uphold the sanctity of the legal profession and the rule of law in the administration of justice in Nigeria. He was speaking at a meeting with lawyers in the employment of the Nigerian police force in Abuja. Mr. Egbetokun reiterated the role of police legal prosecutors and advisors in ensuring adherence to the legal procedures and human rights principles. The Inspector General of Police also urged all police legal officers to remain vigilant in safeguarding the rights of citizens and to step up their game in the defense of the country.
As esteemed legal officers of the Nigerian Police Force, you bear the responsibility of upholding the rule of law and ensuring the dispensation of justice. Your mandates demand impartiality, objectivity, and adherence to legal standards in all endeavors. Moreover, in addition to your specific duties, you are entrusted with the broader responsibility of integrity and independence within the legal profession. You must therefore specifically show commitment to upholding ethical standards, preserving confidentiality, and averting conflicts of interest. I urge you all to discharge your duties with diligence, integrity, and unwavering commitment to justice. In the face of multifaceted challenges confronting our nation today, from terrorism, armed banditry, to kidnapping and armed robbery, our officers all over the nation have exhibited commendable bravery, professionalism, and dedication. However, collaborative efforts are indispensable. We rely on the expertise and guidance of our legal officers to ensure the legality and efficacy of our operations. As officers in charge of legal at your respective commands and formations, you are pivotal in providing legal counsel, prosecuting cases, and ensuring the robustness of our investigations. Your contributions are indispensable in constructing cases that will withstand judicial scrutiny. Against the backdrop of recent reforms in our criminal justice system, including the Administration of Criminal Justice Act 2015, the Police Act 2020, and the drafting of the Nigerian Police Regulations, your role is pivotal in advancing our legal framework and operational capabilities while upholding justice. Addressing the incessant challenges posed by garnishing orders demands our urgent attention. These legal instruments employed to seize assets or funds to satisfy debts or liabilities have become recurrent across commands and formations. While fundamental to civil and criminal proceedings, the complexity of the process necessitates our meticulous attention to detail. I implore you as officers in charge of Lega to prioritize the resolution of the issues of garnishee order targeted against the police. Understanding the legal framework, diligent documentation and collaboration with relevant agencies are therefore paramount. Embrace international best practices, stay abreast of legal developments, seek guidance where necessary, and maintain accurate records. Let us collectively endeavor to ensure that our legal system remains a beacon of hope and justice for all. Through our concerted efforts, we will surmount the challenges posed by garnishee orders and foster a just society in Nigeria. Let us strive to cultivate a legal landscape that is fair, impartial, and accessible to every citizen, irrespective of background.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the Federal High Court sitting in Abuja has granted the application by the Economic and Financial Crimes Commission, EFCC, for the former governor of Kogi State, Alhaji Yahaya Bello, to appear in court for his trial. Justice Emeka Nwite, in his ruling, held that even if the arrest warrant was obtained improperly, Mr. Bello should have still shown up in court. Counsel to Mr. Bello also assured the court that efforts will be made to contact the former governor to appear in court at the next adjourned date. Justice Emeka Nwite subsequently fixed June 13th for Yahaya Bello's arraignment. Staying in Abuja, a former Minister of Aviation, Mr. Hadi Sirika, has pleaded not guilty to the alleged corrupt practices involving about 2.7 billion naira brought against him by the federal government. Mr. Sirika was arraigned before Justice Sylvanus Orji of the Federal Capital Territory High Court, alongside his daughter Fatima, his son-in-law Jalal Hama, and a firm Al Borak Global Investment Limited. The daughter and son-in-law also pleaded not guilty to the 6-count charge brought against them. They were granted bail in the sum of 100 million naira each. Justice Sylvester Orji subsequently fixed June 10th for the commencement of trial. In Lagos, a contractor, the managing director of the Source Computers Limited, Mr. Victor Onyejiowa, has told the State High Court sitting in Ikeja how he was pressured to pay $600,000 for the award of a contract. Onyejiowa, who was led in evidence by the counsel to the Economic and Financial Crimes Commission, Senior Advocate of Nigeria, Rotimi Oyedepo, told the court that his company provided information and communication technology assistance to the Apex Bank between 2014 and 2019. The witness said his company was awarded at least 5 contracts within the stipulated period. The contractor also said that after the contract was executed by his company, he was approached by John Ayo, a former director at the CBN, who testified as the second prosecution witness that the management needed kickbacks from the contract. Onyejiowa said Ayo told him that if he did not accede, the funds meant for the contracts would be delayed by the Apex Bank. Justice Rahman Oshodi has adjourned till May 17th for the cross-examination of the witness. Still in Lagos, the Court of Appeal sitting in the Igboshere area has adjourned till September 16th the hearing of the appeal filed by the chairman of Ibeto Energy Development Company, Cletus Ibeto, challenging the jurisdiction of the State High Court to try him over an alleged 4.8 billion naira fraud. The appellate court, presided over by Justice Mohammed Mustafa, adjourned the appeal to await the report of settlement talks between the Economic and Financial Crimes Commission and the appellant. The 3-man panel of the court also suspended the enforcement of the bench warrants issued on November 3, 2023, against the appellant by the lower court. The anti-graft agency had charged Ibeto alongside his companies, Ibeto Energy Development Company and Odo Holdings Limited, on a 10-count charge of conspiracy, fraud, forgery, and fraudulent use of documents before the Lagos High Court, Ikeja. In Zamfara State, the state government has filed a direct criminal complaint against 8 suspended members of the State House of Assembly before Justice Rukabatu Aliyu Kanoma of the Magistrate Court sitting in Gusau. In a 5-count charge, the suspended lawmakers are accused of forcefully breaking into the office of the Sergeant at Arms and the office of the Clerk to the House of Assembly and making away with some valuable items. Other charges include invading the Zamfara State House of Assembly to illegally search for the mace, to perpetrate a shady and unlawful plenary sitting and destroying valuable properties belonging to the Zamfara State House of Assembly. The State Attorney General noted that all the defendants, by their acts, actions and conduct, committed the said offences contrary to the provision of the Penal Code Law of Zamfara State 2022. The presiding judge has adjourned the case to 30th of May 2024 for the hearing of preliminary objection raised by the defense team. And we round up in Edo State, where the State High Court sitting in Benin has admitted the Benin Traditional Council as party in the suit filed by 2 suspended Enige, Dukes of Benin Kingdom, against the Oba of Benin. The court gave the ruling to admit the Traditional Council following an application filed by the first Defendants Council. The claimants, dissatisfied with their suspension last year, had sued the Benin monarch challenging their suspension, claiming that only the state governor and not the Oba of Benin can remove them from their positions. Benin sons and daughters in their numbers turned up in court on Thursday in solidarity with the revered monarch.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shiele. Thank you for watching and see you next week.